Good morning, everyone, and welcome to Cowan-Harper-Madikizela's last webinar for 2025. I'm sure most of you are feeling tired. You're not alone. We too are tired. The emerging law in South Africa in relation to retrenchments is also something that will give you some sleepless nights. And hopefully we can take you through it this morning. I'm joined by Courtney Wingfield, who's one of the partners at Cowan-Harper-Madikizela in the employment law team, and also the latest addition to our group of best lawyers this year. So congratulations to him. I think we decided to do this webinar on retrenchment law because it's become, relatively complicated, especially over the last 18 to 24 months. And it's become increasingly difficult to advise employers on some of the issues which we'll touch on today. We've also had the Code of Good Practice published recently and come into effect. And for the first time, it deals with issues of retrenchment. There's also the Labour Relations Act Amendment Bill, which may or may not come into effect next year. It seems like it's most likely going to happen. And that also introduces some big changes along with the Basic Conditions of Employment Act, which will be amended. So we thought this is as good a time as any to do a webinar on these issues. Can I just say that the session is being recorded, and if you'd like to rewatch it or share it with somebody else, it will be available on our YouTube channel. We'll take some questions at the end if you have any. Could we please ask that you use the Q&A function in the webinar? So I think let's get straight into it then. Courtney, we've dealt with a bunch of retrenchment issues over the last while. What's happened in the last 18 to 24 months from a case law perspective?
Thanks, Neil. I think the short answer is lots. But I think, just in preparation for this webinar, two cases came out of the LAC last week. Thankfully, haven't materially changed the law, but that just shows the pace at which these things are moving. We've identified four sort of big change cases or clarification cases, really. And I'm just going to go through them just briefly. The first one is a Fisher Tube Technic case. It's a 2024 LAC case. In this case, the employer manufactured steel tubing, including exhausts and things like that. Essentially, one of the clients who provided work to the company closed down its operations, and two employees who became welders were essentially declared redundant. The company issued a 189 notice advising those two employees that they may be affected, and those employees were represented by NUMSA during the process. In response to the 189, NUMSA proposed LIFO and bumping last in, first out as the selection criteria. And essentially, the union's thesis was you can bump the employees into other roles because they have longer service than other employees outside of this particular department. And ironically, what that did was place those two NUMSA members in the place of, or two other NUMSA members in the place of those NUMSA members, which was ironic. But anyway, the company said, well, if we can't bump you vertically in that sense, we're going to bump you, we can't bump you horizontally, we're going to bump you vertically down. And the employees had they didn't have a principal objection to it, but what they did say is that they wanted to retain their terms and conditions of employment, the salary and all of that. Because, essentially, as welders in that department, they earned more than the other roles that they would now perform. They didn't accept those reduced salaries as the alternatives and were eventually retrenched. Went to the Labour Court. The Labour Court found the dismissals unfair on a rather strange basis, but anyway, awarded them 10 months compensation. So it went to the Labour Appeal Court. And if anyone's applied their mind to the issue of bumping, you'll know that it's got a sort of checkered past in the courts, especially the LAC. It's a bunch of judgments that don't really refer to each other, and there's no certainty. And I think this judgment has created the certainty for us. And the judgment starts with just the principles that bumping forms part of LIFO. So, in other circumstances where an employee, the selection criteria say, redundancy or anything like that. Bumping is not necessarily forming part of that. It only forms really part of LIFO. There is no obligation on employers to bump, but it must be canvassed as an issue during the 189 process. Um, and there's an obligation ultimately on the employer to ensure that a fair process remains. But that doesn't mean that an employer is obliged to effect bumping when it is raised. They can reject it and they can have reasons for rejecting bumping. And it's dealt with in a bunch of the other cases that we'll deal with. But generally, the defenses will be it's disruptive and all of that. You have domino bumping and where you bump me, I bump someone else, they bump someone else, and at the end of the process, you have the individual who is identified for retrenchment, and 16 degrees away from him is the person who ultimately is retrenched. So it's one of those situations. The court is eventually found that the refusal of the employees to accept the lower salaries and their being retrenched was not unfair because the employer was trying to save their jobs. And ironically, by trying to save their jobs, by retaining them in the organization, NUMSA or the union or them indirectly caused them to actually lose their jobs. And the question that you really have there is, why didn't the employees just agree to the change terms and conditions of employment? It would have really saved their jobs. But their dismissals were ultimately found to be fair. And that's the case on bumping. Neil, anything to add?
Yeah, just before we move on to the next ones, as you say, the issue of bumping is fraught with difficulty. And often it's suggested as an alternative without any understanding, often from unions, unfortunately, of the implications of the bumping. And I think that once you start with domino bumping, um, I mean, how long is a piece of string ultimately? And I think that there are obviously exceptions in relation to LIFO, retention of critical skills and things along that line of thinking, but it just becomes a problem. So, as a general rule, I suppose, and correct me if I'm wrong, but the law is that it must be canvassed during consultation, but by no means does it have to be accepted by an employer. And it's in fact the employer who needs to raise the issue if the union doesn't.
Yeah, absolutely. And I think the big point from this case is if you do raise bumping as an issue, even realistically horizontal or vertical bumping, there is no entitlement to remain on your terms and conditions of employment. So, it kind of comes back to our thesis, which we'll talk about a bit later. But, if you want to remain at the organization and you raise the issue of bumping, I don't think there's ever been a case of someone being bumped vertically upwards. So you kind of saying to the employer when you raise the issue of bumping, listen, we want to remain in the organization and we'll do what it takes.
Mm.
And that is kind of a mature approach to these things, but in this case where they just said no, we're not going to accept lower salaries or anything like that, it doesn't really help the situation.
Mm. Okay.
Okay, the next case is the famous Coca-Cola beverages case from the LAC. Will any of those who've kept an eye on at least competition law and employment law and the intersection between the two will know that Coca-Cola had they engaged in a merger, and one of the merger conditions was ultimately that no retrenchments must take place. And that's actually a common theme from the Competition Commission these days. But what happened here is Coca-Cola was suffering operational difficulties because of the sugar tax and other issues. The business declines. They've got over 1,000 employees that are affected by Section 189 process. And really the process was that Coca-Cola would reduce the number of pre-sellers, which was a specific role of employees, and eliminate the role of merchandisers, although the title of merchandiser would remain. But the terms and conditions and roles and responsibilities would align to third-party merchandisers who stock shelves and things like that. The selection criteria was really agreed to be LIFO subject to retention of skills, and that's obviously something we now see in the Code of Good Practice. Neil, you'll touch on that. And there was no agreement on bumping, and we get back to the bumping issue. And what the court said was the agreement to bumping wasn't required because of on a national geographic basis, because of the disruption. So this is another, following Fisher Tube, although they don't necessarily cite it, saying that bumping is an issue, but it doesn't need to be implemented in every case. The employees in this case were then dismissed. They referred a claim to the Labour Court, and the claim essentially rested on three parts: that the company breached the Competition Commission's merger conditions of no retrenchments, that there was an insufficient commercial rationale for the retrenchment, which is kind of strange to believe that that could be the argument, and then that the company unfairly implemented the selection criteria. The Labour Court uh, heard the matter. It was a trial matter. They found that the dismissals were fair except for one employee by the name of Mbata, who had applied for a role and hadn't got it, and that's a separate issue. But in the LAC, the court they raised the issue of, well, this is an automatically unfair dismissal because by providing us with an opportunity to apply for other roles in the organization and us not applying for those roles or not getting placed in those roles, we were dismissed for essentially not acceding to a demand of the employer. And we'll all know that that was the thesis of Fry's Metals and Avenge, Try and Steal, and Neil, you'll talk about that, but not really a merit, an argument full of merit. So that was obviously dismissed. The merger conditions issue was kind of resolved in the meantime because the Concord ruled in that case, in a different case, but linked to this one, that it wasn't the retrenchments were causally linked to the merger, and that's something companies must keep in mind, that you don't necessarily need to. If the Competition Commission says no retrenchment, it doesn't mean you can never retrench. It just means no retrenchments as a consequence of the merger or the conduct before the commission. Then the last issue was the selection criteria, which the court basically resolved on the basis that the pre-trial minute had agreed LIFO subject to skills. So the importance of this case was really dealing with the issue of commercial rationale for retrenching. And we'll know that the old law was an employer is entitled to do what they want to do, and the courts don't question that. And obviously, we've moved slowly away from that over the last few years, probably the last 10 years most particularly. And it's now reached this conclusion, which seems to be an amalgamation of old tests, but basically it's the premise starts with the court is not obliged to accept the rationale, the commercial rationale of the employer at face value. It must also be fair as it pertains to the employee. So there's a less differential test now. So we mustn't just look at, oh, the employer thinks that this is a good idea, let's let them do it. And the court cited this Satawu versus Old Mutual, it's an old case where the test really is the dismissals or the retrenchments can't be arbitrary or capricious, and in the general sense, and then there must be a level of proportionality and rationality here. So this is the new sort of buzzword for retrenchment laws, proportionality. And the conclusion there is that the company must really try and attempt to find an alternative that least harms the employee. And that's an important part, and Neil will touch on that later. So the finding here is that there was nothing irrational or unreasonable about Coca-Cola's conduct. Irrationality is that did the measures adopted by Coca-Cola have as a means to an end? Are they any way rationally linked? And then unreasonableness. And the retrenchment was, and the quote is, a rational response to arrest the economic decline. And employers are free to apply for other roles in the business, but they did not do so. So that's another issue, is we mustn't forget that these things happen in stages. So the selection criteria is the one issue, and where the company says, here's the new organizational chart, you are entitled to apply for roles in the new organization, that structure. We can't conflate the issues of selection criteria at the beginning to the issues of not being placed in a role because you didn't meet the requirements for the role or something like that. So that was another argument that the employees tried to make at the LAC, and it didn't succeed, obviously.
Can we just before we move on to the next one, can we just chat about this rationality thing? Because for me, and I know we've spoken about this in the past, this is the biggest development in I think retrenchment law for some time. And I think you mentioned it really, that do the means justify the ends? How do we link the retrenchment to the reasons for the retrenchment, essentially? And was there a different way that the employer could have gone about this? And I this is a new thing, and I know you're going to talk about the Distell judgment, um, because it's an interesting judgment. I mean, I, and we'll talk about it later as well about alternatives that the employer could have adopted. But what is your feeling on this rationality issue? I mean, it's now been introduced by the LAC. Um, where does this leave us in terms of our retrenchment law? We now know that the courts are going to subject the reasons given by employers for retrenchments to a lot more scrutiny, and you'll see that also in the Code of Good Practice. Where does this leave us, do you think?
Mm. I think it really it is a signal away from the old sort of deferential approach. And,
Mm.
quite frankly, reading the judgment in isolation doesn't really make much sense because you have arbitrariness or rationality means to an end, which to me is an easier test to surpass. Did the means in any way justify the end, which is quite easy to meet, I would think. And then reasonableness, on the other hand, is a far more complicated inquiry, which obviously incorporates proportionality, which comes with its own sort of story there. So, I don't think it's the last word on it. And I think,
And then
like,
also, yeah, sorry to interrupt you, but also, I mean, the issue then also is, when we measure this, if we retrench several employees, are the reasons, is the court going to evaluate the reasons that we gave for all of the retrenchments, or do we need to look at each specific employee? Is that where we're going to end up, do you think?
I think that's probably the natural inclination on the basis of this judgment, but I think that would be wrong.
Yeah.
Because then you essentially incentivize people to be belligerent in a process. You know, hold out till the end, and your retrenchment will be unfair. And I think that's the wrong way to look at these things. And we'll see that the risk there in this distill thing as well. I mean, it shows that in that case, we'll get to it, but it shows perhaps we're not looking at a moment in time of reasonability and all of that. We're looking, at the end of the process, whether anyone who hasn't been selected for, redistribution or redeployment in the organization, whether their dismissals are fair, as a whole new essentially retrenchment exercise. And you'll know, Neil. I mean, the LAC has said that you can't do that because then when does it end? You have selection criteria, you get the people who don't get placed, and then you have to apply new selection criteria, and then it's just never going to end. And I think we must just be cautious about that.
Yeah. No, I think you're
Yeah.
right. So maybe take us through Distell. This case blew my mind, but
Yeah.
it's a
No,
good one.
this is a strange one. It's a 2025 case from the Labour Court. And it's Shushu and two others versus Distell. So Distell, obviously, manufactures liquor and distributes it. They employ over 4,000 people. During COVID, there's prohibitions on the sale of liquor and all of that. Business has a downturn. So Distell actually, commendably, comes up with a proposal. Let's ask everyone to agree to a pay cut of 10%, 12.5% for ExCo members to avoid the need, and it's very important, to consider retrenchments. So that's what they say. And basically everyone agrees excepting three people. And in the 1893 letter, which is then issued to these three, the company says we are initiating consultations on the proposed reductions of salaries, which is strange, failing which it may result in possible redundancies or retrenchments. So really from the outset, you see that the company has essentially two goals in mind: reduce the salaries or retrench. And those issues, I think, is where it all comes apart. But anyway, the three don't agree to the reduction or retrenched. The one person, quoted quite extensively in the judgment, is Miss Shushu, who's the sort of name plaintiff or the applicant in this matter. And she said that if she accepted the 10% cut, then she would not have ends meet at the end of the month. And she tried a number of quite creative solutions to try and ensure that she could have ends meet, but it just didn't work. So she refused to accept it, and the other two. So the court starts with the premise, and it's the avenge thing, that employers may change terms and conditions through a 189, and those who don't accept will be retrenched. There's nothing wrong with that. And the court cites the Coca-Cola test as of irrational and reasonable, and says that reasonableness obviously comprises rationality and proportionality. And then proportionality as its own test is balance necessity or suitability. So after going through all of this, which is quite confusing if you read Coca-Cola and the Distell judgment next to each other. Anyway, they get to the point, and I think it's just bird's eye view on this thing, is the three people were retrenched when the company was pressed in court. The real reason that they were retrenched was not for a saving. It was so that the company could ensure consistency and avoid labor disputes, is what the attorney said in response to that question. The company didn't lead any evidence of how 20 million rand saving, which would have been this 10% on everyone's salaries, would have actually assisted the company. And this is most particularly the case when the company had just received a credit facility underwritten by Remgro in the value of 2.85 billion. So 20 million, the whole thesis of the retrenchment, it just doesn't really make sense anymore. And now we look at, is there a commercial rationale? And I think the answer to that one is quite easy. So ultimately, the conclusion of this case was the company was saving 3,538 Rand for 7 months, because we must remember that the cut in salaries was not a long-term saving or permanent saving. It was a 12-month saving. That was the reason for it. So they saved 3,500 Rand essentially for 7 months, and the employees lost their jobs. The court found that that wasn't proportional. Another interesting comment that the court made was when dealing with issues such as pay cuts to save jobs, there must be a proportionality requirement incorporated in that assessment. And basically, the court ultimately found that the dismissals were unfair and reinstated all three of the employees to lesser and larger degrees on the back pay issue. So a strange judgment, but I think ultimately right.
Yes, I think so. But you've got to feel bad for the employer here. It's COVID. They try to get the buy-in of all their employees, and all of them buy in except three. For presumably good reasons, we understand from the judgment. I mean, they need that money to make ends meet, as you said. But by the time they were retrenched, the company didn't need to effect that saving any longer, and then it became unnecessary. And then it was really, as you say, an issue just to ensure that everyone was treated alike. So if the company made any mistake here, it was most likely trying to do the right thing, to ensure that everyone was treated fairly, but it ended up shooting itself in the foot.
Mm. No, absolutely. And I think the big problem here is, you can't really argue a commercial rationale. I mean, we must also look back at the time. COVID wasn't, people weren't, absolutely rational during those times. I mean, people were concerned. We must, just because COVID turned out to be a 2-year or 3-year thing, and the lockdown regulations, the Disaster Management Act, and all of that kind of stuff, I mean, you can appreciate that the employer in the situation said, guys, let's pull together, let's get this over the line. But I think where the employer fell short here was, trying to do both at the same time. Do the 10% pay cuts if you want and see where you end up. And if you end up and you're losing 3,500 Rand a month, I think that's something that you can live with. The other issue is, doing that in conjunction with the retrenchment process is a bit of a strange one. So I think that's where they came undone here. If the employer had just said, we're realigning our operations, etc., etc., we're dismissing this many people because we don't need them or they're redundant or things like that, I think that probably would have come through. But I think by trying to hedge their bets, the employer sort of fumbled.
Mm. I think it was also difficult because the cost saving that they were trying to effect was not permanent. It was intended to be a temporary measure. And for somebody to lose their job based on a temporary measure, I think, maybe they could have found a different way to deal with it. Anyway,
Yeah. Sorry, Neil, just
so
to add on that point, I
mm,
mean, why not affect, in the Fisher Tube thing, as one of the proposals was, why don't you affect a salary increase freeze or things like that? I mean, there's many ways to
yeah.
deal with a problem that exists for 1 year. I mean, even on the company's own version. And I think that's maybe the
Mm.
problem, is that they try to bring a sort of absolute answer to a short-term problem, which is also, like you say, a major issue.
Yeah. So just before you move on to the next case, but and we chatted about all the webinar, but it's interesting because the established law, as we know, is that if an employer needs to effect changes to terms and conditions, they're free to do so, provided there's a commission or rationale for it. And I think in this case there was. They needed to effect a saving of about 20 million. Um, and the established law from the Supreme Court of Appeal and the Constitutional Court, which I'll mention a bit later, is that you are entitled as an employer to dismiss employees who refuse to agree to those changes that an employer wishes to implement. That's what the employer did here, essentially.
Mm,
But because
mm,
of this new rationality and proportionality requirement that was introduced by Coca-Cola, we've almost moved away from that established principle now. So it's going
mm.
to create some difficulty going forward. But I'll chat about that issue a little bit later during my talk. I think you've got one more judgment that you want to
Yeah.
chat to us about.
Yeah, just the other point there, Neil. I mean, would the employer not have just been incentivized to lock the employees out, the three of them? And if they come back, they come back, or whatever stories. I mean, there's other ways. Change it and let them go on strike, or
Mm,
claim a contractual claim in the labor court. And, funny, unique remedies there. The last one, I'm not going to spend much time on it, Neil. It's this recent NUMSA AMSA case, Arcelormittal, where basically there was a 189 process in January to wind down the longs business of Arcelormittal. The facilitation process ends in March. 2 weeks later, the company um, suspends the process and and says that they're deferring it for 6 months because they had a bunch of irons in the fire, so to say. They had IDC funding, they had TERS payments coming through, they had negotiations with NERSA on reduced electricity tariffs. Everything goes quiet for 6 months, and then they issued dismissal notices on the 10th of September 2025 saying, listen, we've reignited this process. So this extraordinary remedy that most of us will know about is Section 189A13, which is essentially an urgent interdict to the Labour Court, which is the bespoke remedy. And the court, just references it to it briefly, say it's a bespoke time-sensitive remedy designed for judicial supervision before workers are dismissed. So the long and the short of this case was because the circumstances at the time of the consultations at March and September had changed so materially, the employer was not entitled to implement the sort of retrenchments after the fact. There were a bunch of developments that had taken place that the unions hadn't had an opportunity to consult on. And essentially the remedy there was the employer was interdicted from dismissing the employees, reinstated the employees, and the parties were required to resume consultations within 10 days of that order. The big problem with this case, which is obviously then a Pyrrhic victory for NUMSA, is that AMSA obviously applied for leave to appeal, and while that happens, the judgment is automatically suspended. So what NUMSA did was apply for an order in terms of Section 18.3 of the Superior Courts Act to enforce that pending the appeal, to enforce the judgment, so the judgment is live. There's a judgment from Witcher that comes after that. It's on the 12th of November, and she essentially dismisses the application, which Neil will touch on for reasons that are kind of obvious that but kind of denude the section. And she says essentially that all of these other remedies in 189 A13, A, B, and C, the reinstate and prevent further dismissals, don't really matter because the compensation remedy that we'll know from Regenesis will still be available to the employees. So just before I close this section, Neil, there were two other, just to mention in passing, there are two other LAC cases that just reiterate the point that, and those are the ones from this last week, that subjective behavioral assessments are not appropriate as selection criteria. The fit in the organization and all of that, and that's another point. I think enforcing the same point that we've had in our employment law for years, but what employers have often used as selection criteria. So that's the section.
Thanks, Courtney. I think that's very useful. Excuse me. So I think the next obvious place to go in terms of the developments over the last 18 to 24 months is the most recent one, and that is the Code of Good Practice. The code now deals with retrenchments. Sorry, I see there was a request made by one of the participants to make the citations available. Happy to do that. We'll
Yeah.
prepare a short document with all of the cases that we mentioned. There's a lot to take in. you would have noticed by now that this is not kind of a beginner's introduction to retrenchment law. This is a little bit more advanced. So we will send through a document just with all of those citations and some high level understanding of each of those cases. But just getting back to the code, I'm not going to spend too much time on it because two of our colleagues, Melisha Haripal and Heda Sensima, had done a webinar, I think about a month ago, dealing with the entire code of good practice. So feel free to go to our YouTube page and you'll find that one there. What's important for today's talk, though, is clause 23 of the code of good practice. Now, for the first time, the code of good practice deals with issues of retrenchment, and there's nothing really groundbreaking in there. It's basically a summary of what's set out in section 189. But why clause 23 is important is because it's essentially a distillation of what our case law has said about employers' obligations in relation to alternatives in particular and avoiding retrenchment. So what clause 23 says is that retrenchments must be a measure of last resort. And we've all heard this and we say this all the time. The CCMA even has posters up that says you must try to save jobs. And the other thing that clause 23 says is that employers must, on their own initiative, take appropriate steps to avoid retrenchments. Now, we also know this, but it's not clear to what extent employers need to deal or what steps employers need to take, how far that extends. Do they need to bend over backwards, especially if now we know that it's a last resort? These principles come from old case law. It's Westhuizen versus Telkom and Algerac, which is also a very old judgment, both of the Labour Appeal Court. So it's good law, and it's been our law for some time. But what it does mean here is by putting these things into the code of good practice, remember the code is something that an arbitrator or a court will need to consider in determining the fairness of a dismissal, and especially in this case for retrenchment. So I think what's going to happen is that we're going to have an increased focus on alternatives to retrenchment. And I think that, as we mentioned earlier, the law is shifting to a place where it's less deferential to employers. I mean, it's always been relatively differential. I mean, it is a court of equity and fairness, but the long and the short of it is that it's difficult for a court to fully understand an employer's business and the dynamics within which that employer operates. So it would have been unlikely to interfere too much. But I think here with this, we're going to have an increased scrutiny from the courts. And I think the reasons given by employers for retrenchments are going to have to be good. We know, and I mentioned this earlier, that the established legal position is that where there are alternatives available. So for instance, if an employer says to you, we can, I'll give an example in a short while, but the employer says, look, we need to cut salaries by 10%. We're uncompetitive and we're struggling. If employees refuse, the traditional legal position established through Fry's Metals and also Avenge more recently is that employers are free to retrench those employees in order to hire people who will work on those different terms and conditions of employment. But you would have seen with Distell that the recent case law developments, I think, have disturbed this position. What you had there was employees who had an alternative. They were asked to reduce their salaries because their employer was in financial difficulty. They refused it. They were retrenched in accordance with the established legal position, and the Labour Court found the retrenchment was unfair. So I suppose the question then is, what if the employer at that point, Distell in this matter, had simply implemented the alternative and saved their jobs? So we know that employers have this obligation to save jobs. It's a last retrenchment, and there is a viable alternative here. The alternative in Distell was just to implement the reduction. Now, what if the employer had done that? In that situation, there would have been no retrenchment. Distell as a judgment would not have existed. And the employer obviously would have complied with its obligations of avoiding retrenchments. So I think these are the sort of things that employers are going to have to think about going forward. And I know there's another judgment that you wanted to mention, Courtney, on a similar issue. I think it's the oily judgment.
Yeah, yeah, absolutely. The problem with it is I think there's a lot of cases that don't actually make it to court. And
Mm,
just so happened that in Distell the employees went to court and they happened to be successful. I mean, we all know how expensive that process is, not only for employers but also employees. So I think we obviously the point that an employee would not have their ends meet is an important point, but you get to the point where losing their job for how many ever many years, it was 2 or 3 years by the time the matter had come to court, and even Miss Shushu, she took over 2 years to get a job. I mean, is that ultimately all in the best of everyone's interests? And I don't think it is, quite frankly. I think you know it goes back to that point that you made about avenge, Neil, is ultimately employers must adapt or die. And I think
mm,
that this is the way in which, we pay lip service to employers must be creative to go and find alternatives. Why not find a reasonable alternative and things like that, and try and impose it, or something like that? I mean, it doesn't get it's not a full answer, but it's something that we must explore a little bit more in detail, rather than just getting to the point of here's our proposals, you don't accept, then you're dismissed. I don't think that helps anyone realistically. Just briefly on this oily judgment, it's one of my bugbears. As you know, restraints have become my bugbear recently, but in this case, the employer, it's a made decision from 24 of the Labour Court. We understand that it's on appeal, but essentially what happened in this case is the company sells and distributes lubrication products. During 2022, previous employee who left the company went out and basically fully solicited and the customers of the company, and essentially acted in unfair competition with the company. Um, this prompts the company Oily to consider its operations and say, how do we protect our commercial interests, our protectable interest here? And what they do is they upgrade their restraint. Their old restraint was kind of one of those bizarre ones that have, if the employer enforces a restraint, it will pay the employee. Although, from a principle perspective, I'm not opposed to that, but that's not our law. And obviously, when the employer came out and said, here's the new restraint, which says you're not going to be paid, and it's applicable across South Africa and not just KZN, the employee obviously said, no, I'm not going to accept that. The problem here is that all 14 of the company's employees excepting the respondent in this case. So it's another situation, shoo and all of that. The company issues a 189. The retrenchment process goes, and the alternative from the company was sign the restraint, the new restraint, and you won't be dismissed. Seems quite reasonable. The employee's alternative was pay me 500,000 Rand plus 24 months salary. And I think we know what happened then. He was retrenched. The company, the Labour Court found that the company failed to substantiate its case, that there was no general need for the restraint. And, I'll give my comments on it now. The company would have to have proved the losses that it would suffer before implementing the restraint, and failed to say why a 24-month restraint in the country was required. So thankfully, the judgment did say a refusal to sign a restraint may be a ground for retrenchment if it's justified. But, ultimately they found that the dismissal was unfair, the retrenchment was unfair, but the matter is now on appeal. That leaves a bunch of questions for me, really, is that the imposition of a restraint really is no limitation on an employee. It only is if the employee leaves and attempts or seeks to compete with the employer. And I don't think, as a principal perspective, that we can say that that's wrong. It's constitutional, and that's what our lawyers found, forever, since the 80s, and from the English law perspective, for the last 150 years. So I think the problem here is that the court may have got ahead of itself and started considering whether the restraint was reasonable at the stage of the imposition as an operational requirement, when the law is obviously that the reasonableness of the restraint is only considered by the court in when the restraint is being enforced. So I think they maybe jumped the gun here. The other issue is that there was no proportionality exercise. I just don't really know what negative effects it has on the employee, other than saying you can't use our confidential information or work with any of our customers in a competitive industry. I don't know if those are unnecessary limitations or unjustified limitations, or whether the proportionality exercise should have been carried out there. I think it should have. So, I mean, just my last say on this is it kind of gets to a point where it disincentivizes employers from evolving. Say, for instance, into AI. You say we're going to set up a crack AI team that's going to go and develop the new ChatGPT, and you none of your employees have restraints of trade, and you can't impose them either. So what do you do in that situation? Do you declare people redundant and hire new people, or it's all these funny things. So I think that we should, and it goes back to, like you said in Avenge, employers must adapt or die.
Yeah, I think it's a very good point you raise at the end. I think, and you'll see with some of the, we'll chat through the changes to the LRA and the BCA, whether they're a good idea or not. To me, some of them are almost counterproductive. But I
Mm.
think just to give some context to this unilateral change issue, we ran a matter ourselves for one of our clients a few years ago, and so this is a real example where retrenchment is not a viable option, even though restructuring needed to take place quite urgently. So what had happened is that the employer had become uncompetitive. For many years, they had given above market wage increases. So this was the culmination of many years of very favorable collective bargaining for the union, which then resulted in a wage bill that was significantly higher than their competitors. So they couldn't really compete, and they were beaten on every single contract they were bidding for. So they realized that they needed to reduce wages, they needed to remove the bonus that had become a term and condition of employment, and they needed to change the overtime arrangements, which were costing them about 10 million rand a month. Um, and this affected over 1,000 employees. They were working around the country at various locations. Um, uh, and obviously, to no surprise, there was opposition from the unions, as I think rightly so. Now, the retrenchment here was not a viable option for employers. So they couldn't apply the fries, metals, or revenge rationale where they said, look, you don't accept the changes, we're going to retrench you. There were various reasons for that. And the first one was that it was simply too expensive to retrench about 1,000 employees. I mean, the severance package payments on that would have required them to take out an extra credit facility or a loan. So it was several millions. They also needed the employees who they were going to retrench. They were placed at mines, and some of them were engaged in an essential service. If they were not there, and it was specialized work, so you couldn't just swap out employees. They needed to know what was being done. If they were not there, there was real risk of environmental damage and also loss of life. Um, and the other reason they couldn't afford it is because if they were to issue notices of retrenchment, of course, the unions would be entitled to go on strike. And then they would have to deal with several strikes at all of their various sites. And this would impact negatively on their relationships with their clients, which may have brought those sites to a standstill. So the 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 employer then considered implementing those changes unilaterally. The union, of course, objected. There were two of them, in fact, and they said it was a unilateral change. And of course, it is a unilateral change. But what they were referring to is the unilateral change in terms of Section 64.4, which permits a strike. Um, so it is a unilateral change, but it's one that's permitted, I think, by Section 189 of the Labour Relations Act. There's lots of case law on this issue to say that dismissal is one of the consequences of a restructuring process. It's not the only one. And if you take into account this obligation to save jobs and that it should be a last resort, why should we retrench 1,000 employees when we don't need to? Now, the issue was never litigated, so the issue was ultimately resolved, thankfully. But the long and the short of it, I think, is that the question then remains, is whether the alternatives need to be reasonable. So if you take this instance, for example, where it would have resulted in a significant change to the employee's terms and conditions, if the employer just implemented the changes unilaterally, um, you can understand the frustration there and the difficulty from the employee's point of view. And of course, this sort of approach is open to abuse. An employer could, notionally say, listen, we need to reduce wages by 50%, and we're just going to implement this thing unilaterally. So we save the jobs, but you are now paid 50% of what you're normally paid. Is it fair? I don't think it's fair. And it's open to abuse. But I suppose it's not as though employees are without remedy here. And uh, I think that their remedy here would be an unfair labor practice, most likely. This issue of the unilateral change in terms of 64.4, I think there's mostly a gap in our law on this issue. It's never been litigated in court. It was obliquely dealt with, I think, in Ekawusa and in national newspapers many, many years ago. But this issue has never received the actual attention of our courts. So,
Yeah.
mm,
Neil, just to jump in there, I mean, should the law not develop to such a degree that that whole if you're redundant, your positions are redundant, you're dislocated, and then you're entitled to apply for those whatever positions in the company. And there's still an obligation. We know from SAB Low, we know it's in Coca-Cola and all of that, that the company must still adopt a fair procedure there in that next
mm,
exercise. And is that not where this issue would be located? Is that saying, guys, listen, here's your new terms and conditions of employment, but you still have a fairness challenge to this thing, and reasonableness
correct.
challenge, I suppose, on the basis of the LAC in Coca-Cola, and then also Distell following from that. So I don't think there's no remedy, because in those situations also not traditionally catered for in our employment law if you just adopt a textual approach to section 189. But what the courts have done is say we accept that the redundancy is not the or it's a selection criteria, and you not being appointed into the new position, that's not selection criteria, but you still have a right to a fair process there. That's perhaps the answer to this question.
Yes. And also, I suppose the case law says the courts have told us on several occasions that employees don't have an entitlement to the same terms and conditions for the entire duration of their employment. Often they would get an increase, but sometimes it may reduce. And it's not helpful often for employees to say that this is not fair. It may not be fair, but ultimately the employer needs to make a decision as to how it wants to conduct its business. And I think there is certainly some difficult decisions that need to be made. I think we've got a few more minutes. I see we've got about 13 minutes left. We'd also like to take some questions. So I think, Courtney, maybe we can just run through the last bit of this thing, and that's really the future of retrenchment law. I think by now, I hope that the delegates on the webinar are kind of understanding how complicated things have become.
Yeah.
I hope we've put that message across. But there are two changes, big ones that we can see, or at least two amendment bills that will impact on retrenchment law. The one is in the Basic Conditions of Employment Act, which I'll deal with quickly, and then Courtney will talk about the Labour Relations Act. But on the BCA, there's a proposal that severance pay will be increased from 1 week per year to 2 weeks per year as a minimum. Now, that at the stroke of a pen will double your retrenchment costs as an employer. So there's a major disincentive here to retrench. There's a schedule, I believe, Courtney, to the BCA that clarifies that this doesn't apply retroactively. It would apply from the date that the law is passed, if it does come into effect. But you've got to understand that this sort of thing will require employers to focus a hell of a lot more on alternatives, because it's simply just going to be too expensive to retrench.
Yeah.
And then you've got to think about the wisdom of this amendment. Courtney mentioned the fact that employers can't progress, but it also doesn't seem to take account of economic realities. While it's trying to disincentivize employers from retrenching, sometimes employers have to do that. Now, when employers are already in a difficult situation, to double the financial pain that they have to pay for a retrenchment is going to really be difficult for them to deal with. Um, it will also, as Courtney said, I think it's going to stop employers from taking risks for their business, because if that risk doesn't pay off, it's going to become a very, very expensive lesson. And I think at a higher level, it probably prevents the unemployed from entering formal employment. Essentially, what it does is create some sort of barrier to entry. So, because there's this disincentive to retrenchment that's or created by this, employers could hire cheaper resources, but this is some sort of artificial regulation of the wage level. So people may be willing to work for lower salaries, but this law will prevent that from happening ultimately, I think. So Courtney, maybe you could just touch on the LRA before we take some questions. You've got some time,
Yeah.
so I need to rush.
Yeah, I think the BCA thing as well, Neil. I mean, it's essentially shifting the social security burden from the state to employers, and
Correct.
and I don't think that's really helpful. If you know, but anyway,
Mm.
the amendments to the LRA are interesting. The boring one is that the commissioner and not the minister may make rules relating to the facilitation and all of that. That's nothing material. We'll all know the old facilitation regulations issued, 20 years ago. So it would be good to get an update for that. The second amendment is that if a retrenchment exercise is facilitated, you're not obliged after that process ends or after the dismissals follow to refer the matter to conciliation. But that requirement remains where the matter is not facilitated. If those of us who have paid attention to it, it's currently come before the Concourt, I think last month, in a different case. And, you know, I think the argument is correct to say that a facilitator's role and a conciliator's role are different. A facilitator is essentially dealing with the operational nuts and bolts of a retrenchment exercise, avoiding um, selection criteria and all these other things, the issues in 189. But the conciliator has a completely different role, and I think that's probably why the conciliations are so successful. So I'm not so sure that is a correct or a useful amendment. But I mean, ultimately, I think the point remains: if the parties really want to settle, they will settle. But I'm afraid it may just create, you know, emboldening attitudes and all of that, where people just say, no, well, we're not going to engage with you any further. I think conciliation in all cases is helpful, and we've seen it. The other
Mm.
issue is excluding sections 189A13 to 18 completely. So this ArcelorMittal remedy is going to be sort of removed in its entirety. And I mean, there is a reason why that is the case. It's because, as we see from AMSA, it's really meritless now. And after Regenesis and all of those cases, is that an employer is kind of incentivized to delay the matter, appeal, go to the Concourt, close down the business, and then um, you'll never have to essentially go back and restart the process, which is kind of the primary remedy of that of the 189A13 is go back, restart this thing and do it right this time. And now it's essentially left to a compensation remedy in 189A13D. So I don't agree with that. I think it's probably a step backwards. I think that amendment, although practically I think it's right, I think philosophically it's probably wrong because it gets to the point where an employer say they run through the process and they barge through the process, they get to the end, and the employees are left with the remedy of either uh, go to the CCMA or the labor court or go on strike. And I think we know what the remedy will be most popular in those circumstances will be the strike. So I don't know, Neil, your views on that?
Yeah, I know I've been back and forth on this issue and I've debated it at length, but I actually disagree with you on this thing. I think that the amendments to um or the proposed amendments to the section 189A13 um are probably a good thing. I think that it doesn't the amendments don't change anything related to the mandatory minimum consultation period.
Mm,
So that's good. The right to strike is retained. And I think that, realistically, um, I think that employees, I mean, there's no difference if you think about it. I mean, the difference between the 189 process as we know it, which applies to so-called normal retrenchments, and then the 189A to large scale, so-called. I mean, the distinction is entirely arbitrary. It's based on how many employees you employ on the one hand,
Mm,
and then how many of that number you intend to retrench. So now suddenly, because of that, you have the ability to rush off in terms of 189A13 to stop the process and take the employees back to consult over the issues. If we're concerned about employers pushing through a process just to get to the end of it, that would happen under the normal 189 process. I don't necessarily think those additional protections are required in 189A. But having said that, this all of these amendments are a direct result of regenesis. We got a
yeah.
200-page judgment from the Constitutional Court. Thank you very much for that. But it's been watered down into these changes. So essentially, the procedural remedy potentially gone in future,
Yeah.
which weirdly may help employers to finalize their retrenchment process quicker. But what it will mean is that in 2 or 3 years' time, they'll have to deal with that procedural issue, um, as they would if it wasn't a 189A. So
Mm.
I think that's really the issue.
Yeah, I mean, there's also that irony now that where in the new labor court rules, dismissals of more than X people get essentially fast tracked,
Yeah.
and this would be an issue that's fast tracked. So maybe you get to resolution quicker, but yeah, it's interesting.
All right, great. I think we've come to the end. But before everyone disappears, we've got some questions, and because I'm facilitating, Courtney gets to answer all of them. And I'll just chip in where necessary. Thankfully, we don't have that many. There is a request for the recording. It will be on our YouTube channel, which we'll send around to all the delegates. The link anyway. There's a question, Courtney, from Paul Nadir. Hi, Paul. If a company employees majority are not unionized and elect their reps for consultation, do you have to invite the minority union for consultations?
Yeah, I think any union, I think it's in 189, any union whose members are affected by the process must be invited to the process. I think that
Mm,
makes sense. Yeah,
very.
I think that's the short answer.
Yeah. Weirdly enough, on the I believe it's the Royal Bafokeng judgment. If you base it on the levels or the hierarchy of consultation, essentially what it means is that the employer would only have to consult with the minority union, and that would be
Yeah,
sufficient. So the majority of employees, even if they're not unionized, wouldn't need to be consulted. It's not good industrial relations practice, I think, but the law says you don't need to consult with them.
yeah, absolutely.
Um,
And I think that also makes logical sense. I mean, these things,
mm,
as you'll know, unions, as much uphill we give them, they do often, most of the time, participate constructively to these things. And having a
yes.
few appointed, representatives, self-appointed, and they go there and they essentially try to destabilize the process may not help. So I think that would work in that circumstance. Yeah.
Yeah, unions absolutely have their role to play in keeping
Yeah.
employers honest. Um, okay, Aruna, how are you? She has a question for you, Courtney. Back to the Distell case. Let's say Distell implemented the pay reduction without the employees agreeing to it, in accordance with the principle of retrenchment should be the last resort. Would the employee then have a case for an unfair unilateral change in conditions? Let's say they have long tenure and would have received a big retrenchment package. I think we
Um,
dealt with that to some extent on the
Yeah,
issue, but
yeah. I
yeah.
think I think the thesis is from the LAC at least is that it's not retrenchment is not the ultimate conclusion. I mean, yes, they would theoretically have a right, a unilateral change right, I suppose, to enforce their contract directly in the labor court. Yes, I suppose they would, but um, you know, is that
Those
productive?
disputes are not arbitrable though.
Yeah, exactly. It could be a
So
labor
if
court
it,
dispute.
yeah, in the Distel case, there were three. So their remedy on a unilateral change case is to strike.
Yes,
But that's
absolutely.
assuming they could strike. As we mentioned earlier, I think the that unilateral change doesn't fall within the scope of 64.4. I think it's a change contemplated by Section 189. But as we said, there's no law on this. So this is from the minds of Coetzer and Wingfield.
The other funny thing about this is, I mean, is the change material? Because then we start getting to contract law, positive malperformance, and things like that. And is it a material change? Is it a true repudiation of the contract and things like that? I mean, those questions will be answered in due course. I think the last part of this is, let's say they have long tenure and would have received a big retrenchment package. I don't think that really factors in too much. I think ultimately the change is the change, and whether it's, in accordance with contractual law or not, whether I don't think the package means anything for that.
Yeah. All right. I think we come to the end. Can we just say thank you? Thank you, Courtney, very much. I think it's been very helpful. We'll be in contact with everyone on the delegates. We'll look out for an email with the links to the video in case you want to share it. And then please also keep a lookout for our webinars next year. Just as a closing remark, we'd just like to say thank you to all of our clients who supported us throughout the year, and also to the delegates who are not yet our clients. And to you, we say, why not? But hopefully we get to meet you in person soon enough. So for everyone, have a good December, get some good rest, and let's get back in January and get back to business. Thanks a lot.
Thanks, Neil. Appreciate it. Thanks, everyone.